I'm going to talk about principle 2. Adolescents are less culpable and more capable of reform than adults, and are therefore less deserving of the most severe punishment. I remember when I first took the bench years ago, that was one of the first things I said to the DA, is that they should be using all of our resources to really work with young people so that we could turn them around and give them an opportunity to not be caught up in the adult system, and that we should spend more money on juvenile justice than on adults. We should basically throw the adults away. So that what we know is that most of the kind that we are looking at for young people is what young children normally do. They experiment, they do things without thinking about them. And it involves risk-taking behavior, but it's part of normal development. And what we should be doing in juvenile court is allowing the young people who come before us, once they are in our courts, an opportunity to develop normally, to explore, to engage in risk-behaving activity, but give them an opportunity to develop the skills that are going to get them on the right track and help them to become the adults that we want them to be. So as those cases were being decided by the United States Supreme Court that Judge Ashby talked about, lots of entities and agencies started to pay more attention to what was being said by the Supreme Court. And so, of course, the Department of Justice stepped in as well. And they agreed that the laws of the land needed to be adapted according to the new wave of cases that were being sent down from the Supreme Court. And that what we were doing needed to match what was being said by the Supreme Court. So later on in this presentation, we will walk through these developmental differences and show how they impact the court process in judicial decision-making at all the stages, starting at the beginning, the detention hearing, the initial proceedings, the advisements of rights, the language, information about attorneys, motions, suppression, discovery, all of the evidentiary issues as well, how it impacts adjudication, disposition, appeals, and post-disposition. Developmental differences have led to a lot of changes in a number of areas around the country. For example, in the detention reform area, we know that detaining young people is detrimental. So you have around the country communities figuring out how to incarcerate less number of people for detention hearings. In the Raise the Age area, in Louisiana, North Carolina, Connecticut, and New York, legislators have been looking at raising the age of juvenile court jurisdiction. Also around shackling. 30 states in the District of Columbia limit the automatic shackling of youth in court. 14 states have made changes in the past years, and you can see that. Illinois, Indiana, lots of states are looking at the how we can reform what we do in juvenile court and make it relating based on what is happening in those cases that have been pronounced by the Supreme Court. In the area of solitary confinement, following states that have prohibited solitary confinement, all Alaska, Utah, Pennsylvania, there are about 16 states. Interestingly enough, in the policy area, there is no minimum age of prosecution in most states. There are a couple of states that have set a minimum age, but most of them have not, which makes us a little bit different from the rest of the world. Most of the rest of the world sets minimum age of criminal responsibility from 12 to 15, but notice that there are a couple of states in the United States have a minimum age younger than 12. But we do that because, again, youth are less culpable and more capable of growing out of non-desirable behaviors. And now Dr. Kavanaugh is going to talk to us about the adolescent development and brain development.